now. All right. Good day. This is a YMCA education series talk. These are free and open to the public, so we encourage you to spread the word and invite your family and friends to participate. We host approximately 6 to 8 of these a month, varying in all types of different topics. This program will last about an hour. And you may find that you have questions during the presentation. We ask you to hold them to the end. Matt will be able to get them. But if you do have any questions while we're talking, chatting, feel free to put them in the chat box, and Matt and I will be able to direct those. We'll get Matt to address those questions. But for mostly, we ask you to hold them to the end. So thank you for joining us today. Today's speaker is Matt Margolis. He has gives these talks about once a month to us. And this month we're talking about Medicaid and assets, how to protect your assets legally, and learn how to strategically protect your assets while applying for Medicaid. He will discuss the ins and outs of Medicaid for nursing homes and supportive living facilities and why it's never too late to protect your assets. And he will also talk about things like a 5-year look back, which we talked about before, but I always enjoy hearing about more. So please, Matt, talk to us more about Medicaid. Welcome, Matt.
Yeah, thanks, Pam. Morning, everybody. Good to be here virtually with you. We all get to enjoy this from the comfort of our own home, which is nice. I know Pam mentioned this, but yeah, if you can keep yourself muted, for the most part, that would be helpful. Unless you promise to have no background noise, then you can unmute yourself. But for the sake of just making sure that there's no background noise and no distractions, I would ask you guys to keep yourselves muted throughout the talk. And so a little background on me. So my name is Matt Margolis, as Pam said. My partner, Lauren Weldon, and I have what I sort of consider a boutique elder law and estate planning practice in downtown Park Ridge, even though I'm a Northbrook resident. And we help individuals, pretty much everybody over the age of 18, with their estate planning needs. So we do wills, trusts, powers of attorney. We do some special needs work. We do a lot of asset protection planning. We do powers of attorney for 18-year-olds going off to college, which a lot of parents don't really think about. And then on the other side of our practice, it's really a highlight on Medicaid and asset protection, and that's what today's talk is about, right? So we'll cover all that good stuff today. Couple things. So Pam did mention, hold questions till the end. I don't necessarily mind taking questions while I am talking. However, these are really my 2 rules for those questions. Either type them in the chat box, or if you are showing your screen, raise your hand like we are back in school. That will pretty much be the only way that will work for me. Because that way, if you hold up your hand, I can kind of finish my thought versus somebody just interrupting me, which, I would prefer that doesn't happen, as I'm sure you would prefer that wouldn't happen if somebody was talking and you were listening. So, but again, yeah, I am happy to take the questions, kind of throughout, because if you're like me, you might forget them. And so the chat box is great for that, if you have that option on your end. So, I guess we'll just get started. So yeah, today's talk is about Medicaid and asset protection. So before we get into any of the asset protection business, let's talk about Medicaid, because we need to have an understanding of how Medicaid works before we can start talking about how to protect assets from Medicaid. So Medicaid, there are various types of Medicaid, but we are going to be talking about what I kind of refer to as long-term care Medicaid. All right, we're going to be talking about the Medicaid that we apply for that helps pay for care in a nursing home or a supportive living facility. All right, now there's Medicaid out there that people apply for that kind of acts like health insurance. Okay, and that's typically for individuals that are sort of living below the poverty line. They might be disabled and receive SSI or SSDI, and they might have gotten on Medicaid as well at some point. We are not going to be talking about that. We are strictly going to be talking about long-term care Medicaid. Okay, again, the kind that we apply for in nursing homes and supportive living facilities. Those are the 2 types of places that Medicaid can be applied for in Illinois. Okay, every single place out there that is categorized as a supportive living facility will take Medicaid. Every supportive living facility in Illinois takes Medicaid. And the level of care that a supportive living facility offers, just so everybody's aware, is really more similar to assisted living. Okay. However, every single place out there that is categorized as assisted living will be 100% private pay. There will be no Medicaid in an assisted living facility. And I can tell you that probably 90 to 95% of any place that has memory care in the title will not be accepting Medicaid either. Okay, probably the vast majority of any place that is under the umbrella of memory care will be private pay, private dollars. Then when it comes to nursing homes, okay, there are plenty of skilled nursing facilities in Illinois. You know, I'm here in Northbrook, the YMCA is here in Northbrook. I'd say within a 10-mile radius of us, there are probably more skilled nursing facilities that accept Medicaid than don't. Okay. But again, I want to make sure everybody understands not every nursing home takes Medicaid. Some do, some don't. Obviously, if you're looking at nursing homes for a loved one and, you know, you don't have, and that individual doesn't have, you know, enough money where we think they'll never run out, it's probably a very good question to ask before we move somebody in to make sure they take Medicaid, right? I won't get into the idea of, you know, a Medicaid nursing home maybe not being as nice as a nursing home that doesn't take Medicaid. I think the one thing that I will mention to everybody today, and something that I really do mean, I've been doing this for 11 years now. I've had clients with various experiences in tons of different long-term care facilities. And I would argue, you know, and I can tell you what I would do if I was moving my parents in somewhere. I would be looking at the place that takes really good care of somebody, even if it's not the shiniest tool in the shed, versus the place that has marble countertops and mahogany countertops, or marble floors and mahogany, whatever you want to call it, but takes really poor care of people. Okay, so just something to consider. And lastly, again, you know, a lot of places on the North Shore take Medicaid. Medicaid does not mean a terrible place. What everybody has to understand and realize is a nursing home is a nursing home. I've been doing this long enough. You know, nobody raises their hand and says, I would love to move into a nursing home. All right, that's just not how things work in real life. That nursing home is the V in the Glen, you know, or the Mather in Evanston. Sure, you know, there are some very, very nice ones. But again, we have to take it with a grain of salt, and we have to really, you know, to me, the concern would be the quality of care. All right, that's enough. I'll get off my pedestal there. Let's talk about Medicaid. So Medicaid for long-term care has there are certain things that I have to, basically there's certain ways that I can qualify for Medicaid, all right? And so really there's sort of 3 tests, if you will. And so they look at our assets, they look at our income, and then they look at what we did with our money over the last 5 years. So first, let's look at our assets, right? So if I'm a single individual applying for Medicaid, I can have no more than $2,000 in my name. All right, $2,000 of total assets. That is the combination of what I have in checking, savings, money market accounts, IRAs, 401ks, cash value of life insurance policies. No more than $2,000. That means I can't own a car as well. The value of the car would go towards that number. I can own a house at the time I apply, but I need to sell it. And then when I sell it, any proceeds I get, I'll have to spend down at the nursing home until I'm back under $2,000. So $2,000 in total assets as a single individual. Okay, as far as the amount of income I can keep, I get to keep $30 a month of my income. Now, here's where there's a difference. In a nursing home, I get to keep $30 a month of income. If I'm in a supportive living facility, I actually get to keep $90 a month of my income. Okay, so skilled nursing facility or nursing home, I get to keep $30 of my income. Supportive living facility, I get to keep $90 of my income. What does that mean? That means that if I get $2,500 from Social Security, I can, pay for the cost of Medicare every month, the $100 plus that I pay for Medicare. If I have a Medicare supplement, I'm going to keep my Medicare supplement. I'm going to pay for that, right? I'm going to pay Blue Cross Blue Shield $200 or $250. There's no harm in paying them because I know at the end of the day, I only get to keep $30 a month of my income. So it makes sense to keep that supplement because there might be certain doctors I see that don't take Medicaid as a secondary payer source. And so having that supplement would be ideal. And at the end of the day, I get to keep $30 a month for spending money. Lastly, we have this look back period. Okay, so Medicaid is going to look back and they want to see, what did I do with my money over the last 5 years? And really what the state or what Medicaid is concerned with is, did I give away any assets? Okay, did I give away money did I write a check to my son who was going through a divorce because he needed help? Did I give my grandson money to help pay for college? Unfortunately, these are good deeds. And it's sort of like with Medicaid, it's like the old saying, no good deed goes undone. Something like that. Because from a Medicaid standpoint, even though I may not have been giving my son money to help pay for the divorce as a way to lessen my assets to qualify for Medicaid, even though I may not have been doing, paying for my grandchild's education as a way to impoverish myself to apply for Medicaid, if I did any of that, and it was within 5 years of applying for Medicaid, the stance that the state takes is that I was doing so to apply for Medicaid. And it will be an uphill battle, and I will not win. Okay? I will not win. And we've seen both sides of this over the years. We've seen sides where people for sure were giving money away to impoverish themselves and apply for Medicaid. And listen, we'll talk about that today. There are smart, strategic ways to do that. But then we've seen the flip side. We've seen situations where somebody was not anticipating Medicaid. Somebody was truly just helping out their son or daughter or grandchild, and they had a stroke out of nowhere at a young age. And all of a sudden they were in a situation where, yeah, they had a decent amount of money, but when you're talking about spending maybe $10,000 to $12,000 a month in a nursing home, a couple of the things they're okay for retirement, especially at a younger age, if that happens, it put them in a really tough financial position. So we've got that 5-year look back to be concerned about. And again, what Medicaid's concerned about is, did I give any money away to anybody else? They're not concerned about, did I buy a $100,000 car? Did my wife and I spend $50,000 on an extravagant European vacation? Did we buy a $5,000 flat screen TV? Medicaid does not care about that. We bought it for ourselves. Now, the one thing Medicaid's not going to like is you can't just, you can't start buying, hundreds of thousands of dollars of diamond rings and diamonds right before you apply for Medicaid. They're not okay with that. But again, everyday expenses, things for yourself, not an issue. If I'm married, my spouse is entitled to a certain amount of assets. So if I'm married and I'm the one that's going in the nursing home, all that information I just gave you is still true. $2,000 limit in my name. I get to keep $30 a month of my income. It's a 5-year look back. But then we have my spouse who's at home. We refer to her or him as the community spouse. Okay, they are living in the community, not in the nursing home. So the community spouse is entitled to $109,560, a house, and a car. There's no maximum value of a home. There's no maximum value of a car. Now, I'm sure everybody would agree, buying a $100,000 car to sort of divest ourselves of our assets in order to apply for Medicaid is probably not the best investment, because that value of that car goes down immediately when you drive it off the lot. But again, my spouse can have $109,560, a house and a car. These income numbers that I'm giving you guys today and the asset numbers are going to be increasing. We just got wind that they will be increasing in coming years. Nothing's increasing for the rest of this year, so I'm not going to discuss any of the new numbers yet. But just so you're aware, these numbers will be increasing. Will start to increase in 2023. So my spouse can have $109,560, a house and a car. She's also entitled to $2,739 a month of income. So I get to keep $30 a month of my income. She gets to keep $2,739 a month of her income. What does that mean? That means that, let's just give you an example. Let's say that, let's give you two examples. Let's say her income, whether she's working or from Social Security, is more than the $2,739 that Medicaid allows her to keep. If it's more, Medicaid has a calculation that they do where she'll get to keep $2,739, but then she's going to have to give a small percentage of all the dollars that she's earning over the $2,739. And she'd have to contribute that towards my care at the nursing home. Now let's use the example that's just frankly more common that we've seen over the years, in that my spouse's income is less, because most spouses, when somebody's applying for Medicaid, are not working, right? Most people at the time of Medicaid application are retired. Not all, but most. Let's just say that my wife's income is $1,500 a month from Social Security. She's under the $2,739. Well, what I can do is, after I keep my $30 a month of my income, rather than the rest of my income going to the nursing home, which it would in a situation where I was a single person, I can actually transfer my excess income, if you will, to my wife to get her up to that 2,739 number. Okay. And then whatever I have left after that, I would have to give to the nursing home. And that would be my financial responsibility every month. We refer to it as patient liability. And then the 5-year look back. Okay, so the 5-year look back applies to both of us. It applies to both of us. So it's not just for me, it's for my wife as well. So Medicaid's going to want to see, what did both of us do with our assets over the last 5 years? They're not just going to be looking at accounts in my name only, or accounts that were joint with my name on it. They're going to want to see accounts that my wife had as well. They're going to want to see her IRAs and 401ks, etc. If we gave away any money over the last 5 years, and we're in a nursing, and I'm in a nursing home, I'm applying for Medicaid in a nursing home, Medicaid will give me a penalty. So let's just say that I apply for Medicaid. I'm down to $2,000 in my name. My wife is down to the $109,560 in her name, the house and the car. We apply for Medicaid and I get approved, but the caseworker says, Matt, we were looking at all your assets and all your bank accounts, and you gave away a total of $30,000 over the last 5 years. And it doesn't matter if it was 4 years and 6 months ago or yesterday. Matt, you gave away $30,000. And let's just say, to make it really easy, the cost of care at the nursing home is $10,000 a month. Okay, so let's say the cost of care is $10,000 a month. Well, the cost of care is $10,000 a month. What Medicaid does is they take the amount that I gifted and they divide it by the monthly cost of care at the nursing home to determine what my penalty will be. Okay. So, and when I say penalty, here's what they do. They say, Matt, you gave away $30,000. Okay, you gave away $30,000. At a cost of $10,000 a month, you gave away 3 months worth of care, right? But for you giving away that $30,000, you would actually be able to pay for this nursing home for another 3 months, and you would basically not have to apply for Medicaid for another 3 months. And so Medicaid says, Matt, even though you are Medicaid eligible today, you need to figure out a way to pay out of pocket for the next 3 months. Right? Even though you're eligible, you're down to the right number, your wife's down to the right assets in her name, you need to pay out of pocket for the nursing home for the next 3 months to make up for the money that you gave away. And then after those 3 months, then Medicaid will kick in and start paying for you. Okay, so that's how works from a penalty standpoint if money is given away. If I'm in a supportive living facility, it's a little different. The monthly divisor, if you will, is not the monthly cost of care. There's a standard monthly divisor to calculate penalties when I'm in a supportive living facility. And that divisor, they use a divisor of $181 a day. So for basically a 30-day month, you're looking at about $54.30 would be the divisor. So if I was moving into a supportive living facility and I gave away $30,000, they would take the $30,000, they would divide it by $5,430, and then that's how they would figure out how many months I would have to pay out of pocket. Okay. So again, we'll talk about ways to plan, but again, there are strategic ways to plan versus just sort of willy-nilly giving away assets to our siblings, our kids, our grandkids, etc. Okay. A couple things to keep in mind here before we start talking about protecting assets. One thing is making sure everybody understands the difference between Medicare and Medicaid. They're very different. All right. Medicare is health insurance, right? This is health insurance that we get at age 65. People that are disabled and that are on SSDI, they can get Medicare at an earlier age based on that, but the vast majority of people will get Medicare at age 65. Medicare is only paying for our medical bills and doctor's visits, and obviously there's differences between Part A and Part B, and I'm not going to go into all that. Medicare is insurance. Medicare does not cover long-term care in a nursing home, other than for a very specific period of time, other than for a little bit of rehab. Okay, so if I'm in the hospital and I am inpatient status for 3 nights, for at least 3 nights, okay? So if I could be in the hospital for a month, I could be in the hospital for a week, I could be in the hospital for 5 days. As long as 3 of those nights, 3 of those overnights, I am considered inpatient status. And then I get discharged to a nursing home for rehab. Most rehab is done in nursing homes. Okay, not all of it. There are some hospitals that have their own rehab, but the vast majority of rehab, at least in our area, will be done in a nursing home. If I have 3 overnights inpatient status, not observation, no other classification, 3 nights inpatient status, and I'm discharged to a nursing home for rehab, Medicare will cover the first 20 days 100%. And then for up to another 80 days, okay, so for a total of 100, up to an additional 80 days after those first 20 days, Medicare will cover 20%. I'm sorry, Medicare will cover 80%. And if I have a Medicare supplement, not an Advantage plan, a supplement, the supplement will pick up the other 20%. So it's possible that I could get 100 days of rehab with no out-of-pocket costs. And that's thanks to Medicare and having a supplement in place. Now, as I say that, most rehab stints are not going to be 100 days. Inevitably, most clients that we've worked with, at least, it's like on day 45, the rehabilitation center calls the family and says, hey, listen, we're having a care meeting. Your loved one is just not making progress. They have plateaued. And in 3 days, Medicare is going to stop paying, and that you're welcome to keep them here long term, but you're going to be paying $350 a day for them to stay here as a long-term resident. Okay, so just be aware that while somebody is entitled to up to 100 days, it will not be that often that people will actually get 100 days of paid rehab. When it comes to Medicare Advantage plans, listen, I am not the best person to talk about these, but they work differently than a true supplement from a rehab standpoint. A lot of Advantage plans will cover that additional 20% that Medicare doesn't cover after the first 20 days. The Advantage plan might cover it for like 20 days, and then you might be out of pocket for 20 days for that 20%. And then the Advantage plan might kick in again after that for like the remaining 40 days. So My 2 cents here is if you got a Medicare supplement or a Medicare Advantage plan, I really advise that you look into it, talk to the person that maybe helped you purchase it, get some information. This is one of those things where that additional 20%, if it's out of pocket for rehab, rehab can be $600 to $800 a day. And so if somebody's on the hook for 20%, 20% of $600, $120. And on a monthly, over the course of a month, it's $360 or $3,600. It's a lot different than paying nothing if you think you're not due to pay anything. So again, it's something that I really advise people to look into. Really, maybe make sure you understand your policies and what they cover. And another thing that I highly advise is if you've got a loved one in the hospital and you think they're going to be discharged to rehab, you need to be checking in with the social worker, the staff. You need to be asking how they're classified. Are they inpatient? Are they under observation? Hospitals have there's a benefit to hospitals to classify people as observation because hospitals' biggest payer source is Medicare. And they don't want to make Medicare upset. So they don't want because they know that Medicare doesn't want every single person that leaves the hospital to go into rehab that's going to be 100% covered by Medicare for 20 days. And then 80% covered by Medicare after that for up to another 80 days. And so we've had clients where they got out of their first month of rehab after being discharged from a hospital, and they got a bill for $20,000 for that first month, right? Because the rehab can be $600 to $800 a day. And they didn't realize that they were not, their loved one was not classified as inpatient status. They were under observation. So you have to make sure you're asking these questions. And if you're having a hard time with the hospital, there are patient advocates out there that you can hire that can help you with that. And they understand the medical side, and they can maybe argue on your behalf saying, you're saying this person's under observation, but based on what they're in for, there's no way this should have been observation. This should have been inpatient. You can get those things changed, but it's harder to do that retroactively, right? You've got to have somebody doing this as it's happening. It's not our strong suit, but you're always welcome to reach out to us. The one thing I'll say is you can always reach out to me with any questions you have that are kind of, and any kind of relation to what you think that we do. And if we don't do it, the worst I can do is connect you with somebody that's really good and they can help you with that specific need. Okay. Okay. So again, Medicare versus Medicaid, very different. Hope you understand what, the very specific situation that Medicare covers in a long-term care scenario. All right, now let's talk about protecting assets. All right, we've got until 10:15. I'm gonna do my best to try to be done in about 20 minutes so that I can have some time for questions at the end. So how do we protect assets, right? So there are sort of two ways that we protect assets. We can do it from a pre-planning standpoint, right? And then we do what we really just refer to as crisis planning, unfortunately, right? There's probably a softer way to call it that, but frankly, that's what it is, right? It's when we're in a crisis. From a pre-planning standpoint, this means that we believe we've got at least 5 years on our side before we need to apply for Medicaid. Now, I want to be sure that we're on the same page. This does not mean that I might not need care for 5 years, or that the person that we're planning for may not need any kind of care for 5 years. This is not what I'm talking about. I'm saying as long as we feel like we've got 5 years on our side before we need to apply for Medicaid. If we think we've got 5 years on our side, we can protect some assets. Now, there are different types of trusts out there, okay? And today is not the talk where we discuss every single type of trust in the world. I'm going to do my best to get through this really briefly, though. So the most common type of trust out there, if any of you on this call have a trust, or anybody that you know, whether it's your mom, dad, brother, sister, friend, etc., colleague, if anybody you know has said, oh, I have a trust, or I put a trust in place, I would say it's probably a 95% chance that it's a revocable living trust. Revocable living trust will be the most common type of trust that we draft in our office. It's going to be the most common type of trust that frankly, any attorney is going to draft for their clients. And this is a document where the vast majority of us are putting it in place to avoid probate. We're going to use this document. We can still manage all of our assets. We still have tons of flexibility. We can do whatever we want. We don't have to give up control. Doesn't change our life in any meaningful way, but we're going to use this trust simply so that at the time I pass away, any assets I have, my house, my bank accounts, my investments, etc., are not going to go through probate, which is the court system where my executor, the executor of my will, would have to hire a lawyer and go to court and make sure that all my stuff goes to the people I want it to go to, which it would if I have a will in place. But we use a trust to avoid that court process. So a trust, for most people, will use it to simply avoid our estate going through court before all of our assets go to our beneficiaries. In some situations, people will use revocable trusts, not just to avoid probate, but to help pay less estate taxes or to totally avoid estate taxes if they have a little bit of a larger estate. Okay, in Illinois, we don't have an estate tax problem unless we're over $4 million in assets. So it's a great problem to have, but the majority of people do not have it. If they do, a trust can work great to protect against estate taxes. So the revocable trust, okay, very flexible. We can make changes to it. Now I would, to avoid probate, I have to retitle my house into the trust. I retitle my bank accounts. I retitle my investment accounts at UBS or wherever my investment accounts are. And I'm the trustee of the trust and I still manage all that stuff and I can still do whatever I want with it. It operates off my Social Security. Literally, my life does not change. My taxes stay the same, etc. Revocable trusts are great, okay? It's what I do for a living, but it's on a little biased, but they're great, okay? Very useful, but very beneficial. However, if we're looking to protect assets, the revocable trust is not great. All right, it's not the right trust to use if we're looking to protect assets from Medicaid. So the type of trust that we're going to use from a pre-planning standpoint to protect assets from Medicaid is what we refer to as an irrevocable trust. All right, an irrevocable trust. It looks and smells and feels a lot like a revocable trust, but there are a couple major differences with the irrevocable trust. And in our office, we actually refer to this trust as an MAPT, a Medicaid Asset Protection Trust, because that's exactly what we're using it for. Most people don't come to us saying, hey, Matt, I'm in a really risky business. I want to protect my assets in case somebody sues me. Well, we can use this type of trust for that, as long as there are no pending liabilities. 99% of the time, we're going to be using this trust to help protect assets from the possibility of Medicaid down the road. And so the irrevocable trust, for me to protect assets, a couple things. I need to put my assets in this trust that I want to protect at least 5 years before I'm applying for Medicaid. Okay, so the assets have to go in the trust at least 5 years before I'm applying for Medicaid. Then how do the terms of the trust work? Well, a couple things. Even though it's my trust and I get to decide all the language of it and who gets what when I die, etc., I do not get to be the trustee of this trust. So if I transfer my house into this trust, or if I transfer my $150,000 brokerage account at Edward Jones into this trust, I cannot be the trustee. I cannot manage or deal with my house anymore. I will not have direct access to that account at Edward Jones anymore. It will be my trustee. 95 out of 100 times that we're drafting this type of trust, the trustee is typically an adult child. Okay, the trustee can't be me and it cannot be my spouse. Okay, even if I'm the only one applying for Medicaid and my spouse is not, neither one of us can be the trustee. So in most cases, it will be an adult son or daughter. Every once in a while, that might be, a niece or nephew for a client who maybe either doesn't have adult children or maybe whose adult children are not reliable. And so typically the trustee will be a loved one, okay, somebody close to us. All right, so I can't be the trustee, so I have to give up control. But then also, I cannot be the lifetime beneficiary of this trust. So if I put my house in this trust and I put my Edward Jones brokerage account in this trust, my trustee can't take the money out and use it to pay for something for me directly. My trustee can't take money out and deposit it into my bank account. I can still live in the house. When it comes to real estate, I can still have all the benefits of the real estate. So really with real estate, there are no issues. Frankly, real estate's the easiest thing to put in these trusts because it doesn't change our lives in any meaningful way. I still live in my house. I can still pay the taxes and insurance and et cetera. No issues with real estate. But with money, with any kind of bank accounts or investment accounts, that money cannot be used directly for me and my spouse anymore. So again, let's just use the example that my son is the trustee. Well, I also need to pick lifetime beneficiaries of this trust. So not just beneficiaries when I die, right? Which is what most of us think about, right? Most of us think about, okay, well, who's going to get all our stuff when we pass away? Great. But that's not what we're doing here, right? So we're still talking about who's going to get it when we die, but we're also concerned about whose benefit is this trust for during my lifetime. And in most cases, the lifetime beneficiaries of the trust will typically be the adult children. Again, in some of these situations, maybe it's going to be the adult nieces and nephews if we have a closer relationship to them. But the trust has to be for the benefit of somebody during my lifetime, during my wife and I's lifetimes. And it cannot be us. So again, typically adult children. What does that mean? That means that if I need to have access to the money in this trust at any point in time, because let's say that over time, the money that we've left in our name outside of this trust starts to dwindle. And we need to have access now to some of this money that we were protecting. And let's say that we needed access to it. Doesn't matter whether it was before we're applying for Medicaid, or maybe we never applied for Medicaid. We just put the money in this trust to try to protect it in case. If we need access to it, we can access it through our trustee and through our lifetime beneficiaries. So what would happen? Let's just say I needed $10,000. My wife and I needed $10,000. My son's the trustee. Him and our daughter are the lifetime beneficiaries. Well, what's going to happen is my son is going to write a check. My son or daughter will write a check to my wife and I for $10,000 from their own personal account. Hey, mom and dad, I love you so much. We love you so much. Here's $10,000. And then what does my son turn around and do? He turns around and he writes a check from the trust to either himself or his sister to reimburse them for the money that they just gave us, because the trust is for their benefit. Right? We're not doing anything wrong. The trust says it's for their benefit, so we can give them money. And our kids are welcome to give us money whenever they want because it's their money. So it's a little bit of a backdoor approach that allows us to still have access to this money if we need it. Typically, when we're doing this planning, the idea is that these are probably assets, or this is probably money that we won't need, right? Rainy day money. We work with a number of clients where their goal is to pass on something to their adult children, something to their kids. And so their idea is, okay, well, we know that if we need to apply for Medicaid at some point, we're happy to, spend a lot of our assets doing so, but we'd like to set something aside. And so this is one way to do that. I say this is one way. This is probably our favorite way of doing it. Again, I don't love the idea of just giving money, writing a check for a client to write a check to their son or daughter, because the issue is, what if their son or daughter just spends that money? Then it's not there for my clients if they need it down the road. Right? What if somebody sues their son or daughter? Their son or daughter gets a divorce. This money that they gave them, or this real estate, right? I've got clients that think it's a good idea to put their kids on their properties or transfer that lake house in Wisconsin directly to their kids. Again, their kid gets sued, their kid goes through a divorce. That asset is now available in those situations to the creditors or to the soon-to-be ex-spouse. All right, for the sake of time, I'm going to jump and talk about some crisis planning. But again, I just want to make sure that everybody understands, in the situation I just discussed, I'm setting money aside that I can still have access to down the road through a trusted person. This planning, just so everybody's aware, really doesn't work in situations where somebody does not have adult children or that they can rely on, that are very trustworthy, or maybe like adult nieces and nephews that are super trustworthy and reliable, or maybe grandchildren that are very trustworthy and reliable. Unfortunately for those people that don't have any, don't have any kids in general don't have any nieces or nephews they can rely on, it really just doesn't work. Okay, we need that support system to act as a trustee, to act in that lifetime beneficiary capacity. Okay. When it comes to crisis planning, we use we use the same type of trust. We use this Medicaid Asset Protection Trust. But the difference is, in a crisis, we're talking about a situation where, you know, Pam comes to me and Pam comes to me with her mom and says, hey, Matt, you know, my dad, you know, my mom's husband is in a nursing home for rehab. And we just found out that Medicare is going to stop paying, right? We found out he plateaued and Medicare is going to stop paying in 5 days. We need to keep him there. We can't bring him home. Okay. We can't afford, you know, home care for him. And it's just too much for my mom, et cetera. And so we want him to stay at the place that he's at getting rehab long-term. And you know, he's used to it now, right? So he's been there for 40 days or 60 days, et cetera. What can we do, right? My mom's concerned that she's going to run out of money. And so let's just say in this situation that Pam's mom and dad have $300,000 in a house and a car, okay? Even though we don't have 5 years on our side, we can still protect assets at the last minute here. And the way we do that is, you know, so we look at the fact that I don't need to work any magic for Pam's mom to keep $109,560 in her name, right? I don't need to work any magic for that because that's what the state allows. Now, we're just going to call it $100,000 for sake of easy math. So, okay, so we're going to say that she gets to keep $100,000, her house and her car. And as good as I am at doing what I do, I don't get any credit for that. But there's another $200,000, right? Because we said that Pam's mom and dad had a total of $300,000. There's another $200,000 there. And if we do nothing at all, that $200,000 will get spent both on Pam's dad's cost of care, and obviously Pam's mom's got her own monthly expenses. But at $10,000 or $12,000 a month, even presuming that Pam's mom's monthly expenses are pretty reasonable, that money is probably gone. That $200,000 is probably gone within 2 years, right? And that's taking into account that they've got Social Security or pensions or some monthly income coming in as well. But let's just say without doing anything at all, that $200,000 is likely gone in 2 years. It doesn't matter when it's gone, but that $200,000 will get spent. And then when they're down to the $109,000 and $2,000 in the dad's name respectively, they can apply for Medicaid. Well, instead of waiting, what we can do is we can put a plan in place, okay, kind of what we call the crisis plan. We can put a plan in place today. And what we're going to do is we're going to take roughly half the assets that are over the $109,000, and we're going to put them into this Medicaid Asset Protection Trust. Okay. So again, we're saying that there's $200,000 at risk. We'll use that phrase, at risk. So we're going to take $100,000. We're going to put in this trust. Now we know, based on what I said earlier, if everybody was listening, we know that if I put $100,000, if we put $100,000 in this trust, Medicaid is going to give us a penalty. And the reason why they give us a penalty for this type of trust, if it wasn't obvious, is that the trust is not for my benefit, right? It's not for, or in this case, it's not for Pam's mom or dad's benefit. The trust is for the benefit of Pam and her siblings. And so when the $100,000 goes in this trust, the way Medicaid looks at it is basically no different than if they just gave, if Pam's parents gave the money directly to their kids. All right, so there's a $100,000 gift to the trust. Well, let's just say that this nursing home, again, to make it easy, costs $10,000 a month. The nursing home's going to say, hey, you got a 10-month penalty on your hands here, right? You give away $100,000. It's $10,000 a month. You have a $10,000, you have a 10-month penalty. But remember, we still have another $100,000 out there that we need to do something with, right? Because it was $300,000. We put 100 in the trust. They get to keep 100, 109, but we're calling it 100. But there's another $100,000. So the other $100,000 goes into what we call a Medicaid compliant annuity. Now, my disclaimer here, I'm not a financial advisor. I'm not an insurance salesman. I don't have my insurance license. Using this annuity, it provides zero benefit to me or my law firm. And annuities typically being sold in the context of being sold to older individuals are typically a no-no, right? We see this with clients all the time. They come to us and 80% of their net worth, and typically it's not a very large net worth, but 80% of their net worth is in annuities that they can't touch for 8 years without a surrender penalty. And they're like in their late 70s. So they can't touch 80% of their estate for 8 years without a surrender penalty. And they were sold this annuity in their 70s. Not saying annuities aren't okay, but need to be diversified, and diversified way better than that. But I'm going to get off that pedestal. This is not an annuity that has a surrender penalty. This is not an annuity that's being sold in a bad way. This annuity serves a very specific purpose. Okay, I want to make sure hopefully everybody can understand this. I gave away the $100,000 and it triggers a 10-month penalty. I've got $100,000 left that I need to do something with because my spouse, or sorry, in this case, Pam's mom can only keep $100,000. So this other $100,000 goes into this Medicaid compliant annuity. The way that this annuity is going to work is we're going to say, hey, insurance company, here's $100,000. And then what they're going to do is they're going to turn around and give it back to Pam's dad in 10 equal monthly payments. So every month during that penalty period that Pam's dad and mom need to pay out of pocket to cover the full amount of that monthly rent due to the penalty that was created when we gave the money to the trust. Every month they're going to get an annuity check that, coupled with their income from Social Security, et cetera, it will be enough to pay the nursing home. Okay, so for 10 months, they're going to get payments from the annuity. They're going to pay the nursing home because of the penalty. And at the end of month 10, there's no money left in the annuity. And whether or not the Medicaid application has been approved by then, and trust me, in some situations, it will be approved within 10 months. In some situations, a Medicaid application might take 12 to 18 months to get approved. But at month 10, they are done paying the penalty. They are done paying out of pocket, other than whatever their, if you remember this term from earlier, whatever their patient liability amount is based on their total monthly income. But they are done paying the full amount after 10 months, regardless as to whether the Medicaid application has been approved or not. It's been approved, great. If it hasn't been approved, Pam's dad is still Medicaid pending, and their only responsibility to the nursing home is whatever their monthly liability is based on their combined income. So I know this can be a little tricky to get across in a meeting like this. Sometimes it's a lot easier for me to do by drawing pictures, etc. But I'm hoping this made sense. And the gist of it here is that in a crisis situation, even if we're applying for Medicaid at the last minute, we didn't do any pre-planning. In a lot of cases, we can protect about 50% of the assets above what Medicaid would allow them to keep, would allow somebody to keep. Now I'll tell you, the little asterisk here is, whether this person that's going into the nursing home and or their spouse do they have capacity to put this kind of trust together? If they don't have capacity, do they have a power of attorney for property that has the right language that would allow their agent named in the power of attorney to put this type of trust together, to do this type of planning on their behalf? I can tell you right now that most standard, your standard Illinois statutory property power of attorney, which is, we're just for purposes of our conversation, we'll call that like the standard power of attorney for property, the financial power of attorney, will not have the right language that would allow the agent to do this type of planning. So if somebody does not have capacity and they have sort of that statutory power of attorney for property, we very well might not be able to do this type of planning that I just discussed. So the one thing that I always advise people on is that if you think this is something that you could see coming down the road for yourselves, for your mom or dad or brother or sister or cousin or whoever you're potentially on here getting information for, it's probably not a bad idea to get their powers of attorneys updated. Because there's situations where I'll meet with families and literally they're like, you know what, there's probably not a whole lot we can do. And sometimes, we meet with a lot of families that kind of fall in the middle of these two types of plans, right? They probably don't have enough time on their side for a 5-year asset protection plan, but their loved one isn't moving into the nursing home tomorrow. And so we can't do the crisis plan. The crisis plan only works if somebody's in a nursing home. You have to be in a nursing home for that crisis plan to go into effect. But you've got some people that kind of fall in the middle. What we'll recommend in a lot of those cases is, listen, we may not be able to do a whole lot now, but it would make sense to update the power of attorney so that if in a couple of years your loved one is in the nursing home, we would at least have the ability to engage in some asset protection planning. Again, maybe we'll never need to do that planning, but if we update the power of attorney, at least we have the ability then to do it. Because I'll tell you, I've met with clients over the years where they were gung-ho, they were all for wanting to do this type of planning, but the individual was already incapacitated. And obviously not everybody that moves into a nursing home is mentally incapacitated. Some people have more physical issues and mentally they are totally there. But we've had plenty of people where they came to us, they were very interested in doing this type of planning, but their loved one was incapacitated. They didn't have the right language in their power of attorney. And really not having, that language in the power of attorney prevented us from protecting anywhere from $50,000 to a couple $100,000 of assets. So I really can't, at most talks I give, I talk a lot about powers of attorney in the beginning. I didn't do that today because there's a lot of other information that we needed to cover. But I can't tell you how important power of attorney documents are for healthcare and property especially. I mean, both especially. I shouldn't say just property, but making sure that people have these in place and that they're up to date and that they're comprehensive documents as well. Again, most even estate planning attorneys will not have the right language, not the right language, but not have this language in their powers of attorney documents. It's typically going to be language that you're going to find that, most attorneys that do what we do, which is more estate planning and elder law. Any attorney that has elder law in their practice typically will have this sort of added language to the POA because we add it ourselves. It's not part of the statutory form, which most attorneys use. I'm not tooting our horn, but this is our area of the law, right? This is what we do on a daily basis with folks. And so we make sure that we've got documents that will allow families to engage in planning that will help protect assets. So I went a little bit longer than I said I would, but I really wanted to make sure I covered all the information. So, I've got about 5 minutes, and I'm happy to answer any questions anybody has. And I appreciate everybody. Three of you I can't see, but I appreciate you staying and listening.
Any questions from Matt? I'm always interested and baffled by how much how you're able to keep $30 a month of your, like what, and you're like for spending reasons. And I'm like, $30, like.
I know that number is going to change next year. And the 109. So actually, I'm not sure about the $30, actually, to be honest with you. I got to look into that. I know that the amount for the spouse will change. So the 2739 is going to go up to, I think, 3435. So it'll go up significantly. It'll go up by about $700, which is a lot. I mean, it's been at 2739 since I've been doing this, and I've been doing this, as I said, for a little over 11 years now. And then the 109,560 that the spouse gets to keep, that number will be going up a little bit every year. It'll go up a little bit until it gets to, I think, the federal number, which I'm forgetting what that number is, but I want to say it might be getting up to about 130,000 or so over the next maybe 5-6 years, which will be nice. So what's good is that I think people are realizing, that $30 a month number, I mean, that hasn't really changed since the 50s when Medicaid went into effect. I mean, so you're talking about think about how much the cost of living has gone up since the 1950s. I mean, it's insane that, somebody's only getting $30 a month. But, you also look at the fact that, the state is covering their cost of care, and somebody in a nursing home typically doesn't have a ton of additional expenses.
Yeah.
Truthfully. Yeah. But yeah, I get it. Listen, some things I agree with that the state does and a lot that I don't.
Yeah. It's just interesting. I've heard you say that before, and I've just always wanted to comment on it. So there you go. Any other questions? All right. Well, if there's no other questions, feel free to message myself and I can get the message to Matt, or Matt.
I'll put my email in the
Perfect.
chat box.
I was going to say, he
Email
knows
is
his email. Good.
for sake of making it easy on me, I'm just gonna put my email in there, but email is the best way to contact me. I'll just say it to everybody. And if email is not good for you, I'll put my phone number in there. You can always call. I'll just let you know that you will always get a call back from Mike in my office. He is the one that will return all my calls, and he is awesome. So, but I appreciate everybody's time today, and Pam, I appreciate you and the YMCA for hosting these, and for continuing to have me on.
Yep.
Um,
Thanks.
and what's should we talk about what's really I'll bring about what next month is?
Yeah, next month. Sorry, next month. Oh, you got it.
It's planning strategies for the caregiving child.
Yep.
So we'll talk about just things to consider if you're, if you're that adult child that's taking care of mom or dad or grandma or grandpa or your aunt or uncle. There's just certain things to consider. And so, if you fall into those shoes, if those are the shoes you're in, then it might be worth your time.
That talk will be on August 3rd, Wednesday at 9:15. We'll hope to see you there. Our next talk is Tuesday, July 19th at noon. Know about the 10 signs of Alzheimer's from the Alzheimer's Association of Illinois. So with that, everyone have a great day. Thanks again, Matt. Stay safe.
You got it.
All right.
Bye, everybody.
Bye. Thank you.